Welcome to the Migrant Center's Policy Analysis Podcast. My name is Sarah Ramey, and I am an immigration attorney with the Migrant Center for Human Rights. Today we will be discussing the Executive Office for Immigration Review's Notice of Proposed Rulemaking that was placed into the Federal Register on November 27, 2020, and is available for public comment until December 28th at 11:59 p.m. Eastern Standard Time. The Migrant Center for Human Rights has prepared a public comment that can be used as a template, and that information will be provided at the end of the podcast. This proposed rule on motions to reopen and reconsider, effect of departure, stay of removal, deals with three different parts of our immigration law. First, looking at motions to reopen and reconsider. The administration acknowledges that fewer people will be able to have motions to reopen and reconsider granted. Basically, the process will become more difficult, the process will become more time-consuming, and fewer people will be able to overturn these deportation orders, even if they now have a legal way of remaining in the United States. We feel this rule is particularly problematic because it requires adjudicators, whether those are immigration judges or panel members at the Board of Immigration Appeals, to ignore the merits of an individual case and basically not grant that motion to reopen or reconsider. Briefly, the difference between a motion to reopen and reconsider is that a motion to reopen is based on new evidence, and a motion to reconsider is where there may have been an error in the application of the law to the facts of the present case. But for all extents and purposes, they are treated similarly in the Notice of Proposed Rulemaking. So we will be talking about them together. So the proposed rule, first of all, says that the individual must show their likelihood of success, and raises the standard. So previously, for someone to, or I should say currently, for someone to have their motion to reopen or reconsider granted, so they would have a chance to say, hey, adjudicator, I have a legal way of staying here in the U.S., that's going to become more difficult. First, because if that is based on any type of collateral matter that is still pending, the judge or the panel member is going to be barred from reopening. So that's individuals who have DACA, individuals who have TPS, individuals who have a U.S. citizen spouse who has petitioned for them, where they have an approved I-130, where USCIS has said, yes, this is a bona fide marriage, let's go on to the green card process. That person, if they have a prior removal order, would be ineligible. And so typically what we would do is we would go to the immigration judge and we would say, Your Honor, can you please reopen this case? And we're also moving to terminate proceedings because this person has a path to becoming legal permanent resident. And so that would no longer be an option under a plain text reading of the proposed rule. The other thing that's required here is that individuals have a nuanced understanding of our immigration laws. And this is especially problematic for unrepresented respondents. For those who have an attorney, not as difficult, but still is going to, it's going to be harder. And that is because the proposed rule establishes that the person must show a reasonable probability of succeeding if their case is reopened or reconsidered. And we would suggest that there should be a reasonable possibility, because under reasonable probability standard, the administration is basically asking us as attorneys and pro se respondents to present all of the arguments and prove the case with all the details and all the evidence at the motion stage. Traditionally, motions have been looked at as a method to then move it back into proceedings where all of those steps would happen. So an individual need to make a prima facie case. yes, if all this is true, then there seems to be a decent chance. Let's give the opposing party an opportunity to do research and respond. Let's bring in the respondent or other witnesses and have them testify, right? Now, much more of that is going to have to be proven at the motions stage, okay? One of the reasons why this is problematic, in addition to it being hard for pro se respondents, is it's going to make it much more time consuming to prepare. It's going to be more costly, so it'll be harder for those who have a little bit of money and could maybe otherwise hire an attorney and now won't be able to because the attorney says, I just simply can't do it for that amount of money. So it's going to deny people access to counsel. And in taking longer, it's going to make it harder for people who are in detention, who are facing imminent removal. I sometimes will only give a person, if at all, 24-hour notice. And so for that person to get their paperwork together and to file may be incredibly difficult. I should say is incredibly difficult, but will become more difficult under the proposed rule, to the point of it being impractical and, in effect, impossible. So this legal method, this system of correcting errors within our broader judicial process is effectively going to be denied for people who are in detention. And so for that reason alone, this section of the proposed rule should be withdrawn. The other issue that the administration creates with their proposed rule is they say that individuals who are submitting evidence at the motion stage cannot have that evidence considered as evidence. And this really makes very little sense because if the person has submitted a human rights report from the U.S. State Department, right, these are always taken as admissible by adjudicators and usually given very high level of weight, right? They're considered to be very relevant and very important documents. This rule doesn't allow that possibility. It establishes a per se rule that nothing submitted at the motion stage is considered as evidence. The purpose of this, of course, is to prohibit documents and evidence that are not relevant, that are contradicted, etc., from being given too much weight. But what the proposed rule is talking about and establishes is not a matter of weight, it's a matter of admissibility. So really, the system as it stands works. It doesn't need to be changed. But if the administration feels like it needs to change the system and clarify the language, then it should be focused on the way our judicial process works and has been established and developed and applied by adjudicators around the country for decades, right? And that's that the judges can look at the evidence, determine whether or not it's likely admissible. They don't need to make a ruling at the motion stage because, again, they don't need to go into that level of detail. But they can say, okay, I think this would likely be admissible. I think I would likely give it this amount of weight. Therefore, let's get this case reopened on the docket and let's see if we can resolve this issue, right? Because I see that there's a legitimate legal question here and this person could very well be eligible to stay in the United States. The proposed rule also says that motions to reopen are barred for individuals who were deemed to have filed a frivolous asylum application. A finding of a frivolous application is done when a judge decides that there was no basis for filing for asylum. So this is not a case that was weak and lost, right, where the person's really afraid but for some reason doesn't fit within our strict criteria for asylum. This is a case where the person has no fear, basically, and they're just trying whatever they can do to stay in the U.S. Typically, this is viewed as a misrepresentation, right, to the U.S. government and is taken very seriously and bars individuals from most forms of immigration benefits. However, we do have statutory obligations that relate to our international treaty obligations. So the United States is a party to the protocol, the Refugee Protocol, which incorporates the convention, and as well as the UN Convention Against Torture. Now, the individual should still be able to get their cases reopened for a finding of protection under the Convention Against Torture, because effectively you have with your Convention Against Torture Protection gives you a deportation order, right? This is just you applying to have that stayed, right? So it's sort of like a fairly long-term temporary stay while you have a danger in your home country. And withholding of removal functions similarly, but under the asylum framework, and it doesn't give the same benefits as asylum. So really, most individuals are going to be going for asylum because that's the only path to a green card and to basically any ability to bring spouses and children and other family members to the United States. And also has some benefits that help the person adjust to their life here, et cetera, et cetera. So in a situation where somebody has a case where the finding was frivolous, right, and they believe that was incorrect, they can't ask for the judge to reconsider it. If they get new evidence, they can't ask for the judge to reopen it. Okay, if there was a coup in their country, and now they have a case that's based on different facts, okay, they can't ask for reopening or reconsidering. So it seems like there may still be a pathway for protection of the Convention Against Torture and withholding of removal, although that's not clear because procedurally you would have to get your case before a judge, right? And the method to do that would be to reopen or reconsider, even though you don't need to actually have that deportation order canceled to get those forms of relief. But asylum would definitely be impossible for anyone in the situation. So again, the administration is creating a per se rule that's only going to serve to harm people when there's really no need to do that, right? The other thing that is going to happen with these motions is that if they are granted, only the issues that were raised in the motion can be considered. So if there was a collateral matter, for example, the person is now eligible for a U visa, or now has married a U.S. citizen, right? They cannot bring that up to the judge. And this may be a better form of relief for them in terms of the benefits. It may be a quicker form of relief for them, right? It may be therefore more efficient and effective for all parties, right? Including the court, and the court, of course, is paid by U.S. taxpayers. So this is relevant to all of us as the public, beyond the issues of values and morals. So this doesn't really make sense. Okay. The other thing that can happen is that when a new issue comes up, you would think, well, okay, if I can't include it, now maybe I'll just do a new motion to reopen. Well, you can't really do that for two reasons, right? Number one, a motion to reopen is if your case is closed, and your case is not closed. So procedurally, there's not really a method. I suppose a clever attorney could ask to amend their initial motion and see if the judge would go for that, even though they've already made a ruling on it. But the motion to reopen and the motion to reconsider regulation allows for one of each. They are limited in when they can be filed, and unless you get the judge to reopen sua sponte or you get DHS to join, there's really going to be, once one motion has been filed, there's going to be really very little opportunity to file a new one. Procedural cartwheels aside. So these are some of the reasons that we believe the administration should be withdrawing and no longer considering this proposed rule, that it really shouldn't be taken into consideration and made into law within our system. So I'd like to now move on to the second thing that this proposed rule does, and that is how it's changing the definition of departure. So the rule says if you departed the country on your own, it was a conscious decision to forego further presence in the United States. As a result, any pending motions to reconsider or reopen are canceled. Okay. Based on our experience at the Migrant Center, we've seen a number of people who leave the U.S. for brief departures, usually somewhere between a couple of weeks and a couple of months. They're not intending to give up their life here with their family and their friends. They are returning often to take care of a very sick elderly relative, or to attend a funeral of a loved one. And so this proposed rule is going to put them between a rock and a hard place, right? It's going to require that they either forego any ability of being there for their family, and continue their case, or that they give up their chance of being in the United States legally, and instead be with their family. There's really no reason that the rule needs to do this, and we would certainly ask that the government, that the administration withdraw this portion of the rule as well. The last part of the proposed rule deals with stays of removal. So a stay of removal is basically a grant, usually for a fixed period of time, of permission to stay in the U.S. And it's usually associated with a pending legal matter, to give the person time to sort through whatever they need to sort through. So what this proposed rule does, it actually does several things. But first, it requires that stays of removal cannot be filed with the Executive Office for Immigration Review unless they've been filed with DHS first. So this is usually going to be an ICE officer. And they either have been ruled on or they've been sitting there for 5 days and there's no decision. Now, individuals currently have the option of filing stays of removal with DHS, right? That's Form I-246, or filing with the court, right? They can do both simultaneously. They can do one and not the other. They can do the court stay before the DHS stay. This rule limits that. Okay, and the real problem with this, the most sort of glaring issue, is that individuals sometimes find out about their removal orders, or I shouldn't say their removal orders, but their removal date, right? Very quickly. So they may find out about their removal. Typically, the quickest cases are going to be Mexican cases, right? Because we share a border and it's very quick to remove people there. So the person could be ordered or removed by an immigration judge. They may be seeking counsel to do a motion to reconsider. And in, 4 days, they're deported, right? And they don't hear about their deportation until late the night before, when the money in their commissary account is basically withdrawn, because ICE is going to give that back to them when they leave. So this requirement that DHS has to look at this case in 5 business days, right? So we're talking potentially a week or longer, depending on if there's a weekend or holiday involved. That basically this person is effectively going to be removed. The proposed rule in its introductory language says, a stay request in emergency circumstances could be filed with the court. However, the actual rule does not create an exception for emergencies. And the actual rule uses language that is very strict. DHS must have subsequently denied or failed to respond to the request within 5 business days. Must have, right? So all else being equal, the language is not going to permit for emergency stays, despite what this extra language that's not part of the regulation says. And so we definitely believe that at a minimum, the administration needs to take that introductory language and work it into the actual regulation. And they need to lay out clear standards. What would be considered an emergency situation, right? The other problem, of course, with this is that it gives authority to, or sort of gives preference to DHS, which is the enforcement agency, right? DHS is where the prosecutors are. DHS is not a neutral party. Individuals with regards to judicial matters should have access to an independent adjudicator, okay? And that's why sometimes we choose to file with the court and not with DHS. And so, DHS sometimes is the better place to file. Sometimes they're going to agree to stay, but not always, right? And that's a very case-specific decision that should be made in consultation with counsel, and not put into regulation as a per se rule. The other issue here is that DHS is not typically in the best position to make a decision on the underlying issues at play, because the underlying case is going to involve a lot of legal considerations, and deportation officers and CBP agents are not attorneys. They're not judges, right? They're not versed in immigration law. They don't get training in immigration law by and large, right? And so, they don't have all the tools to really make a decision in some circumstances. And that's the first part of the stay proposal change that's problematic. Second part of the new language that is problematic. The proposed rule states that if the immigrant has failed to comply with a notification to surrender, it may result in a denial of the alien's motion, right? So if the person has an order of removal and, they basically don't follow through with their voluntary departure plan, or they don't show up to ICE to be removed by ICE, they're considered an alien fugitive, right? And they're quote unquote on the DHS blacklist, right? And we're not talking about people with criminal history here. We're just talking about people who are not complying with their deportation order. So, certainly not legal action, but, we're not talking about a crime that's caused harm to anybody. So the proposed rule says this is a deliberate flouting of the immigration laws. But it ignores the fact that by seeking to reopen a case or asking for reconsideration, the individual is actively seeking to have the U.S. immigration law applied correctly to their situation, right? The person is doing what they're supposed to be doing, going through our judicial system. And so to deny them that opportunity to have their case considered simply because they're not wanting to comply with their deportation is very contradictory, right? It's very problematic. The other point on this is that our immigration system, by and large, is separate from other systems. So our immigration system is largely separate. Our immigration laws are considered civil, right? They're largely separate from criminal laws in the criminal system. There are certain places in statute, right, where to, for example, demonstrate good moral character, the judge will look at criminal history, but the judge is not supposed to go in and re-adjudicate at criminal matters. And so the proposed rule is overstepping a little bit here. So the proposed rule is not talking about a criminal issue, because failure to comply is really, again, broadly within the immigration ambit. But it is a law enforcement issue, right? And there is a process and a system designed to deal with this issue in the context of DHS. And there's no real need to say that an individual really shouldn't have the ability to reopen their case simply because of this other sort of collateral matter. At most, the administration really needs to clarify the language in the proposed rule. right? The language basically says, this may result in a denial, but really indicates that it should be the basis of a denial, because good cause has to be established to grant a motion. And, it's basically saying, well, we don't think there's good cause if the person is not complying. And so, this could certainly be something the adjudicator looks at, right? But the proposed rule, doesn't create the proper sort of weight as this being really a discretionary factor, and not one that should be, closer to a per se rule. Having this as part of the regulation is also going to make it a disincentive for people to come out of the shadows and legalize when they do have legal ways of remaining in the United States. So, we're looking at, a system that is not helpful to our society, is not really appropriate or necessary in terms of the fact that it will be causing harm, right, for no real good valid reason, and potentially through a certain amount of lack of clarity, can lead to abuse and disparate results, which is something we always try to avoid in searching for fair administration of justice throughout our system. The other thing that the proposed rule says on stays of removal is that the likelihood of success on the merits, the likelihood of irreparable injury, harm that the stay may cause to other parties interested in the proceeding, and the public interest must all be considered. Okay. This is going to increase the burden of the pro se respondent or the attorney to prepare these stay requests. Again, this is going to make it take more time, and it's going to eventually make it more difficult for people who have very quick turnarounds in their cases. So with that, we will conclude, and we recommend that everyone read the language of the rule, look at our public comment, and before midnight Eastern Time on the 28th of December, submit your opinion, why you think this rule would be helpful or harmful, from your position, in your words, to make sure that the administration knows and understands where you're coming from. Thank you again for listening today, and have a wonderful rest of your day.